You're live, Judge.
Okay. All right, we're going to trial. We're going to, I'm sorry, not we're going to trial. We're going having a hearing on this Versailles case. Plaintiff's counsel, if you can go ahead and make the announcement with the case name and the cause number.
Tyler Smith on behalf of Plaintiff Versailles Dallas Inc. Cause number DC 18-15106.
All right, defense counsel.
Your Honor, it's Jonathan Scott on behalf of Jordan and Aaron Zatoon.
And Joe
Okay.
Ackles on behalf of Jordan Zatoon.
Okay. All right, let's go ahead and proceed.
All right, Your Honor, if I may share the screen.
Let me see. I'll go ahead and enable that. There you go.
All right, Your Honor, this is the affidavit, or this unsworn declaration of Jordan Zatoon in this matter. Aside from some of the testimony, which has its own issues there, I would just direct the court to the exhibits because I think that's going to shortcut and short circuit this whole deal. If we go to paragraph 23, they're suing on a contract. This is a summary judgment where they're suing on an underlying construction agreement that has been settled by the parties, and plaintiff is suing on the settlement agreement that was breached. Of course, there's a difference between what defendants think plaintiff is suing on, but the pleadings are pretty clear. But in any event, a true and correct copy of the builder's agreement with the building plans and specifications omitted. And earlier in the affidavit, he actually testifies that he omits the budget as well. In any event, they're attaching this Exhibit C, which they've testified is not even a complete document. And there's a reason that it's not complete, because I mean, it would pretty much go against their entire case, but they're moving for summary judgment on a contract, which they are not even attaching the entire contract to their motion, let alone proving it up and what's necessary, and it is irrelevant. But plaintiff would move to strike the Exhibit C, the contract made the basis of their motion, as an incomplete document, and as it's simply not relevant to this case, given this is a suit on a settlement. That is, they could have sued us if they thought that there was a issue with any sort of construction, anything of that matter. They could have sued us, but they waited until they were sued under a settlement agreement to launch some of the most frankly, tenuous claims I've ever seen. They're suing for RICO violations at this point. It's very clear what's going on. But in any event, there is numerous fact issues that will foreclose their motion. But we would ask, just as a matter of law, that Exhibit C, the contract made the basis of the motion, is struck, and the objections as far as the incomplete and relevance are sustained.
Your Honor, Jonathan Scott, the contract and the pertinent provision, if we can move to the previous page, I don't know whether I can do it or he can. The operative provision that is at issue in this case is paragraph 6, Your Honor. And it says all changes and deviations in the work ordered by the owner must be in writing, the contract sum being increased or decreased accordingly by the contractor. Any claims for increases in the cost of the work must be presented by the builder to the owner in writing, and written approval of the owner shall be obtained by the builder before proceeding with the order change or revision. So this builder, Your Honor, after collecting, as his predecessor counsel acknowledged in our March 9th hearing transcript, reporter's transcript, was fully paid the fixed fee of $507,000. Nevertheless, in direct violation of his own contract, which the builder drafted, they made claims for extra money. And that's what they sued us over, claiming that they did extra work. Now, counsel, of course, has a different recitation now that there's been a change of counsel. But reading from the reporter's transcript, this is what the predecessor counsel said. This is the March 9th, 2020 transcript, Your Honor. Mr. Ertl, who's the predecessor counsel for Versailles, says, "Okay, thank you, Your Honor. James Ertl for the plaintiff." This is page 5. Just a little bit of brief background about this case. It was originally my client is a home builder. They built the defendant's home that's at issue in the case. The contract price was paid. There was some additional work that was done on behalf of my client, which exceeded the contract price. There wasn't anything in writing, but there were agreements between the parties and what that would cost. Ultimately, that amount was due by defendants to my client, and the parties, my client ultimately filed a mechanics lien based on the amount due. So, and it goes on, but Your Honor, so on April 10th, 2018, Versailles filed a $75,000 mechanics lien claiming extra work in direct violation of paragraph 6. And so our motion for summary judgment, counsel says it's based on all these affidavits. Well, a lot of that is because they filed a no evidence summary judgment on our counterclaims. But our motion for summary judgment is very simple and straightforward. We start with the written agreements between the parties. There's 2 agreements. There's a document, this builder contract, which was never amended, that required written change orders. This transcript in which there's a judicial admission that they have no such change orders. And I'd also.
But there's if I understand what's going on here, there's a settlement agreement that occurs after this all occurred, right?
Correct, Your Honor.
That's
And
not
they're
true,
very-
Your Honor. And that's where
Well,
Mr. Ackles' argument on the motion to strike the affidavit is critical. That's a
The only
sham
evidence,
affidavit, and we'd
the
like
only
to-
evidence of that.
Well, one
settlement-
at a time, guys, one at a time. Mr.
Let me-
Ackles, let him
Thank you,
finish,
John.
and then you can go. Go ahead and finish.
Your Honor, I would pass this to Mr. Ackles because he was going to argue this issue of whether or not there's a subsequent settlement agreement as they claim.
Okay.
What happened was, once they saw our case, they changed entirely their position in this case. And for the first time in 2020, asserted there was a quote settlement agreement. Mind you, it's a verbal settlement agreement. And that the only evidence of that before the court is this reply brief declaration by one of the El Shamis, where he first inserts the words, it was a quote settlement agreement. That's the only presented evidence to the court. And in that declaration, he says he doesn't have he does not state he has personal knowledge of those facts. He simply states he's familiar with the facts. He knows, they know how to write a correct evidentiary affidavit because they've done it before in his El Chami's declarations in a motion for default judgment before this court, where it was based on personal knowledge, where they never mentioned the settlement agreement. But now, in the 11th hour, and for the first time, they try to present evidence that is not appropriate or proper summary judgment evidence. It does not meet Rule 166A requirement of being based on personal knowledge. And that's why I said this whole charade, I think, is a legal fiction that they now claim it's a quote settlement, an oral settlement agreement that has no evidence to support it except for El Chami's naked declaration with personal knowledge. That he claims that this promissory note that's in writing and signed somehow evidences the settlement agreement, but it never mentions a settlement agreement. It never mentions a release of claims. It never mentions a release of warranty. It never mentions the release of them having to do any more work to bring a house that doesn't have a certificate of occupancy and has so many defects it leaks. He never mentions any of that. There's no writing of any of that. It's just a naked assertion on an affidavit that doesn't support summary judgment. Since it's not based on personal knowledge, and since there's no pleading by the defense that any agreement is ambiguous, you can't present parole evidence to somehow bootstrap oral agreement of settlement. And there's a Supreme Court case right on point that such conduct is a sham affidavit. And unless the other side explains why his affidavit seeking a default judgment in this court said nothing of a settlement agreement, and yet his affidavit supporting the reply brief asserts a settlement agreement, they have to explain why there's a difference in that opinion. They don't even present anything to the court to explain it. And the Supreme Court said in the Lujan case, 555 Southwest 3rd 79, that's a sham affidavit, and the trial court should not rely on it. So that's why that we strike that.
Response.
Your Honor, okay, if I may, there's a lot there, but if we look at this transcript that they're obviously relying on, number one, plaintiff objects to it. It's an incomplete transcript. It's a select number of pages. It hasn't been filed of record. They can't talk about a transcript that's not fully filed. The complete transcript's not filed. That aside, they're saying they've never heard of a settlement agreement. Their very evidence, suing based on the breach of that settlement agreement. I'm confused of why they're shocked that this is a settlement all of a sudden. To that point, just to get to this is to the response, but this is after. I note they haven't objected to any exhibits either that have been attached to the declaration of Mr. El-Chami. But they're saying there's flooding, a lot of issues there. September 22nd, that was about 3 months after the settlement agreement. Heavy rains, our home flooded last night. Hardwoods are ruined, living room. There isn't proper drainage. These are all their claims in this suit. We don't have money to fix it, and it's really upsetting. Well, that's a common theme in this case, is they don't have money, but we go to this. I know it's not your problem. I'm just letting you know. Now, why are they going to pay us a $61,000 note, a $15,000 check that bounced, by the way, have flooding, according to them, 17 times or whatnot, and then just 3 months later, I know it's not your problem. I'm just letting you know. It's not our problem because it was settled. I mean, we can go through exhibit after exhibit. I know it's not your problem. Money is just as important. I want to get a game plan how to get you paid back. I can't pay the credit line to Sam. I'm not trying to pay you all you're owed. I mean, this could go on. And I'm deeply distressed. This new information, it puts our current home construction, more importantly, our relationship. I want to make things right. Can't withhold this, when you're doing work. I promise to make things right with you guys, and we will get you the 75,000. You just have to trust us. I'm shocked that they're even disputing anything here, but yeah, if that would be the 75, and then at least it's a bit smaller. Indeed, it was a lot more. The parties ended up settling for less, but there's just so many deficiencies with their case. But as to the breach of contract claims, the affidavit of Mr. El-Chami, which would be this Exhibit A, there's case law. Well, Dallas Court of Appeals, it does not have to state verbatim it's based on personal knowledge. There's no need that it expressly avers that facts are based on personal knowledge or that they're competent to testify, as long as it's clearly stated. They're suing this man who's made the declaration. He's clearly, everything he's saying is based on communications which have not been objected to, but were attached here. And he's clearly proven his basis. He's familiar with the records. It's a business record affidavit nonetheless. And
So he says, as such, I'm personally familiar with the facts of this case and contents of this declaration. I'm not sure why that language was chosen exactly, but is there any case, I've reviewed hundreds and hundreds and probably thousands at this point of summary judgments. I'm not sure I've ever seen anyone use that terminology before. Is there any case law that says that's sufficient?
there is, Your Honor. It's, I could cite Dallas Court of Appeals, City of Dallas Continental Airlines.
That says personally familiar is sufficient?
No, but it just says that you do not need to expressly aver that facts are based on personal knowledge and that the affiant is competent to testify if the facts clearly demonstrate personal knowledge. Here, and then there's another, need not recite that an affiant has personal knowledge when the facts are such that it can be considered within personal knowledge. And that's a Texas Supreme Court case. Here, this man is integrally part. This is not a president of a company getting told something from, someone down the chain of command and just reciting things in an affidavit. This is the point of contact in this whole suit between the plaintiffs and defendants. And he's actually a third-party defendant. And I personally communicated with defendants via email and text. And ironically, they even put in their own affidavit that they went over to his house and executed documents. And so they're at least even admitting this is personal knowledge. But these things, and then of course at the end here, I declare under penalty that's true and correct. But this is there. It's clear that these are things that are within the man's personal knowledge. And
All right, so I need to get this hearing moving. So let's kind of go through each of the different issues you want me to rule on here, guys. So what's the first thing you want me to rule on?
First thing we would ask, the objection to Exhibit C of plaintiff's motion, the contract at issue, is stricken. The objections as to incomplete and relevance are sustained.
All right, that objection is overruled. So what's the next thing we need to rule on?
I was going to make my motion to just strike the declaration of Chami as not based on personal knowledge.
That's denied. What else what's the next thing?
Your Honor, well, we also had the other component of our motion to strike, which is a sham affidavit, but we'd like, Your Honor, we want to be able to show you, the docket of the prior affidavit on the motion for summary judgment, in which he describes this as a promissory note in exchange for a release of lien and not a settlement or a release.
That motion is denied. All right, what do we have next?
Your Honor, Exhibit D to plaintiff's motion. First of all, these checks, these are apparently the payments, they're saying, construction draw. These payments are for Tulip. That is not the project at issue here. Tulip, they're completely irrelevant. That said as well, these draw payments here are incomplete, and I'll represent to the court these amounts, these highlighted amounts that they're referring to.
So you want me to strike this, Mr. Smith, is that right?
Yes, Your Honor.
That's denied. What's next?
Exhibit E. Honor, we'll move on.
That's denied. What's next?
Okay, Exhibit F, City of Dallas. These are not properly authenticated. They're incomplete. These are just a couple pages from some sort of record of the City of Dallas. No attempt to properly authenticate these documents.
How is that authenticated, Mr. Eccles or Mr. Scott?
I believe I'm not sure if we referred to a judge, but my understanding is this is what was produced by Versailles Dallas that was acquired from the city of Dallas. It's the permit file, Your Honor, from the city of Dallas, showing that the permit was revoked.
Is that true, Mr. Smith? Was that produced by y'all?
I unless it has a Bates label, I cannot definitively.
I can't see because you're now on Exhibit G, I think.
No, this is Exhibit F.
Oh, is it?
Yeah, these have no Bates label, and if December 3rd, 2018, I would tend to believe these were produced by the defendant, or not even produced, but at least pulled by the defendant. At this point, I don't believe they had even answered the lawsuit. Possibly doing.
Did you I don't know. Did you Bates label all the discovery? Is that?
Plaintiffs did, yes, Your Honor.
All right, so I'm going to go ahead and grant the motion to strike F. What's next?
We would ask to strike the transcript. It's an incomplete transcript. The full version.
That's denied. What's next?
The check for the purchase of a Lexus, completely irrelevant. I'm not even sure really what that has to do with anything. It's a check from before the contract.
Why is this? Yeah, why is this in here?
Your Honor, it's for proof of value. What he doesn't tell you is that part of the extra consideration that they insisted on taking from the Zatoons is they took their car, this Lexus, and they sold it.
Okay.
So this is just to show the court what was paid to buy the car.
That's denied then. Was that Exhibit H or I?
That's J, Your Honor.
J. There is no H. There's no I guess. Okay. J is denied.
He didn't argue H.
Oh, okay. Sorry. All right.
Or I.
Exhibit K, Your Honor. This is a text message sent to Jason Boley by Sam Elchami. We would argue on grounds of hearsay.
Who is Jason Boley? I don't know who that is.
He was a mortgage broker, Your Honor. But we're offering it with respect to the statements that are made here. The only thing we're relying on in this exhibit is the item in blue, which is a statement by Samuel Elchami responding to the question that Mr. Boley asked him.
In other words, the truth of the matter asserted, apparently.
It's an admission, Your Honor. It's a statement by Mr. Elchami. And this was produced by them and by Elchami's counsel, former counsel in discovery.
All right, that's denied. What do I have to rule on next?
That's it with respect to the exhibits.
Okay. What's next?
We would ask paragraph 6 here. I was left with an incomplete home on a lot that was ungraded. The builder collected $17,000 for cleanup. Basically, these are just,
that's denied. What else?
Paragraph 9. We had no legal assistance or attorney at the time, but Versailles did. That's just irrelevant.
Sustain. That sentence is struck.
Paragraph 10. In Elchami's affidavit, he claims past due as of April 10th. This is not true and did not follow the builder's agreement we signed. That's just conclusory relevance as well.
Denied.
Paragraph 12, Versailles was overpaid and its claims are all untrue.
Granted. That's granted.
Paragraph 13, builder sued us because he claimed the loan on the promissory note had matured.
Denied.
And paragraph 15, I was in court. Mr. Erd will say that Versailles was paid the full contract price.
Sustained.
True. Okay. That's it, Your Honor.
Okay. All right. What do I need to roll on next?
Your Honor, we have our affirmative motion for partial summary judgment. We're asking for partial summary judgment or summary judgment on liability with regard to our breach of the builder contract claim. And it's based upon the builder making claims and collecting in excess of the $507,000 fixed amount that was agreed in the contract and thereby breaching the agreement. And we're not relying on statements by parties. You know, counsel is raising all kinds of hypothetical or fact issues. What we're relying on, Judge, is the parties have a written agreement that controls, two written agreements, as we've said, that control the relationship. The first one is the March 2nd, 2016 agreement. As I've drawn to the court's attention, paragraph 6 unequivocally required that there be a written amendment to the contract before the builder made any claims for increases in the cost of the work. That's what it expressly says. And it is uncontroverted and in fact judicially admitted that no such change orders or writings were ever presented to the Zatoons by the contractor, which is what his obligation was. And therefore, as a matter of law, the builder was bound to the $507,000 fixed price. That's what the parties agreed to.
Let me ask a question here because I want to make sure I'm kind of honing in on the right thing. So is the allegations made by it's a little confusing. Okay, so defendant's motion for summary judgment is trying to move that Versailles claim for breach of contract. Okay, I'm getting a little confused here. So we have we have plaintiff Versailles has a breach of contract claim just for the $75,000 or $76,000 allegedly because of the settlement agreement. Is that right?
That's
Well,
correct.
no, Your Honor. Yes, $75,000 or $76,000 claim for construction extras, which they say were evidenced by a check and a promissory note.
Your Honor, let me point something out. They're moving on the first amended pleading or first amended petition. They're relying on a petition. They're moving on a petition that's been amended. And it was in fact amended before they even set this hearing. They didn't have to set a hearing. I mean, that's why I'm just confused with what the basis of their motion is even and what the grounds are.
Mr. Smith, what causes of action does your client still have?
It's a breach of contract cause of action.
For the settlement, just for the settlement agreement? For
the settlement agreement, yes, Your Honor. And we've also alternatively asserted a UCC claim based on the bounce check, but certainly that'd be alternative to the settlement agreement.
And nothing else?
No, Your Honor. No quantum merit, no equitable claims. Just those issues as to the settlement agreement.
All right, and that's what the summary judgment's about. I just want to make sure I have the full scope of the summary judgment.
There's summary judgments about prior issues or with their interpretation, I guess, of the lawsuit, which is, on its face, their document is the summary judgment on all claims by Versailles in the first amended petition. Well, there's a second amended petition on file with the court, Your Honor, and it was It was filed back in June.
So what were the difference between the second and the first?
I mean, there's no quantum merit claim, but it's just been cleaned up. It was making clear as to what the breach of contract was, because they're seeing that they're saying there was a breach of a note or a construction agreement or something, but really the issues become it was a settlement for the issues that the construction agreement were.
Judge, may I respond?
You may.
The difference between the pleadings is that in the first amended petition filed by predecessor counsel on February 20th, he indicated that it was a breach of contract claim referencing a promissory note and a bounced check. And he said it was in the form of a settlement agreement. But now what's happened is with new counsel, with their amended petition and their El Chami affidavit, this suddenly becomes that the promissory note has a contemporaneous, according to them, or concurrent verbal addition to the provisions of the promissory note that add or rewrite that promissory note on the same date, according to them, to make it so that the promissory note would now have a general release, so that it would now have it would say that it subsumes or is the successor to the prior residential construction contract, that it's a waiver of the 1-year warranty of workmanship after completion of the house, and none of it is there. And so as Joe was saying before, Judge, we've been litigating this case since 2018, in which they started the case by asserting a claim on a promissory note and a check. And in their motion for a default judgment, Mr. El Chami says that was the agreement that he wanted a default judgment on. That supposedly was the agreement. So this is as Joe said, this is a legal fiction. They put the terminology settlement, but what they're trying to do, Your Honor, is rewrite their own promissory note to put in provisions that are just not there.
Your Honor,
they claim it's contemporaneous and concurrent on the same exact date.
Your Honor, we could move for a summary judgment on the promissory note as a matter of law, and I think that would be pretty straightforward. I'm not following counsel's argument, but I mean, it sounds like a fact issue to me, quite frankly. I think they're kind of making that evident, but just this simple email, and I'll represent to the court, there's many more where this came from, but our home flooded last night. That's part of their claim, breach of contract.
That's not the part of our motion, Judge. We're not seeking summary judgment on the construction defect aspect of this case or the revoked certificate of occupancy. It's a motion for partial summary judgment on their collecting and claiming additional money and filing a lien in violation of their contract. And, Your Honor, that there is no consideration or proof that any of these numbers that they claim were owed is a valid debt. So counsel never talks about that, which is in response to our motion for summary judgment, in which we cited the authority as to the elements of a claim on a promissory note, that it requires, of course, as a contract consideration, but also requires proof that the debt is due. They have not provided any such proof. This is on a residential construction contract in which they are required to keep and maintain all of those records under the property code under 162 and be able to show us what the ledger is of the checks. None of it is here.
Your Honor, they're jumping around. I think the promissory note itself evidences the debt, but essentially what this claim, to simplify this whole deal, they have these claims under some theory that
Mr. Smith, I get it. I'm denying the summary judgment. Is that all we have to rule on today, guys?
Your Honor, there's actually a plaintiff's no evidence motion that we would just assert that they have not properly shown that the individuals are parties to the contract, and they've in fact said that it's a fact issue as to who the parties are to a no evidence motion, which is the wrong standard, of course, but the defendants have not put forth evidence that, and in fact, if we want to talk about sham affidavits, we can go to, and this was attached to their response to no evidence as well, but throughout the affidavits of both Mr. and Mrs. Attune, we hired Versailles. Versailles repeatedly. We were handed a written, our agreement with Versailles, without bulky plans, with Versailles. Versailles is overpaid. Then from Miss Attune,
Okay, so,
Versailles built our home.
so let me hear a response on this.
Sure, Your Honor. So what counsel's not showing you is the contract that they drafted, and they've taken the position that the contracting party is Versailles Dallas Inc. exclusively, but yet the recital in the top of the agreement says, this agreement is hereby made and entered into the second day of March 2016 by and between Jordan Zatoun, Aaron Zatoun, hereinafter called owner, and Versailles Custom Homes, parentheses, Sam L. Chammy, comma, Dylan L. Chammy, hereinafter called builder. And at the bottom of the document, it's signed by Dylan L. Chammy, no corporate capacity indicated. And it says home builder Versailles Dallas LLC, which is not even a valid separate entity from the L. Chammys.
Well, Your Honor, I would expect some evidence to that effect if on a no evidence motion for summary judgment, but there's simply none, and they've taken a contrary position, in fact, and that's an issue.
This summary judgment is denied as well.
Okay.
Anything else, guys?
No, Your Honor, we will get you orders.
Just get me order, guys. I hope you're safe out there. And when are we set for trial in this case?
September 22nd, Your Honor.
Jury or non-jury?
Jury trial.
Jury trial, yeah. So I have no idea if we'll actually be having jury trials by that point. I hope we are, but I doubt it. And we'll just keep you updated. Just get me an order as soon as you can and try to get it to be agreed to if possible. All right?
Thank you.
Sure. Thanks for the court's time.
No problem. You guys be safe.
You
Bye-bye.
too.